Welcome to Law Minds. Today's topic is Memorandum of Association. So, I would like to begin by giving a brief description about what Memorandum of Association is. So, Memorandum of Association is a legal document which describes the purpose for which the company is formed. It defines the powers of the company and the conditions under which it operates. So it is a document that contains all the rules and regulations that governs a company's relationship with the outside world. Now coming to the introduction part. The Memorandum of Association is a public document, and every individual and every person who is working under that company or who is a part of that company is presumed to have sufficient knowledge of the contents and provisions which are provided in the Memorandum of Association. Now, what is purpose of a Memorandum of Association? The first point is a Memorandum of Association is the constitution of a company. Now, why does it say that it's a constitution of a company? It's because it is a mandatory for every company to have a Memorandum of Association that defines the scope of its operations. Now, the second point, it is the charter that defines the limitations of a power of a company established under law. Meaning that once a memorandum of association is prepared, the company cannot operate beyond the scope of that document. So there are certain limitations which are attached, and the company is not supposed to go beyond that. Now, the third point is that it contains the fundamental conditions under which a company must be incorporated. So, the foundation of a company is the Memorandum of Association. The entire structure of the company is detailed in the Memorandum of Association. So, the company must be incorporated according to the Memorandum of Association. Now, coming to the fourth point, it determines the powers, objects, and limits of a company. So every company has powers, objectives, and limitations, and these are described and detailed in the Memorandum of Association, and accordingly the company will be operating. Now, what are the clauses in the Memorandum of Association? So I will list the clauses. First one is name clause, registered office clause, objects clause, liability clause, capital clause, and association or subscription clause. Now let's go into detail about what each of these clauses are. Now the first clause, that is the name clause. So a company can have any name of their choice. But according to Companies Act, the name clause is mandatory and that must be included in the Memorandum of Association. So the company's name could be anything, but it should be included. Now, it also specifies certain conditions, which is according to Section 4, Clause 1A, that a name of the company should end with private limited or limited for a company is limited by share, or unlimited for a company not limited by shares. Now, 4 Clause 1A states that if a company is a public company, then the word limited is to be used. And if a company is a private company, then the private limited should be used. Now, there is a certain section, that is Section 8, which is not applicable to this condition, that it describes companies which are established to promote commerce, art, sports, education, research, social welfare, etc., religion, etc. So, Section 8 companies are similar to trust in societies, but they have better recognition and legal standing than trust in societies. Coming to the next one, that is the registered office clause. Now, this clause is also known as a domicile clause. Under this clause, the part of the country is mentioned in which the registered office of the company is to be situated. So, this registered clause, in that clause it is said that the Memorandum of Association must state the registered office address of the company, and this address determines the jurisdiction under which the company is registered and where legal notices and official communication will be sent. Now coming to the next clause, that is object clause. This clause defines the primary objects for a company is formed. The objects clause specifies the activities the company is authorized to undertake. Any activities beyond the object clause would be considered beyond the legal powers of the company. Also, the object clause is a major portion of the Memorandum of Association, and it contains all the major objectives which the company might undertake in the future. Now the next clause is liability clause. So the Memorandum of Association must specify the nature of liability. If the liability of the member is limited by shares, or it's guaranteed, or it's unlimited, all this will be provided in the liability clause. So like I said, the extent of the liability of each member of the company will be determined in this clause given by each member. Now coming to the next clause, that is the association clause. This is the final clause of the Memorandum of Association, which contains a declaration by the subscribers stating that their intention to form a company and to become the members of it. This clause is signed by the subscribers who are the initial shareholders of the company. So the association clause is a fundamental clause, and it is also included uh, according to the Companies Act 2030. It specifies the name of the company, the state in which the registered office is situated, and the objects for which a company is formed. Coming to the alteration of the Memorandum of Association. So if the company wishes to alter the content or the provisions which are provided in the Memorandum of Association, then it can be amended, but for each clause there is a different process for amendment. So the Memorandum of Association can be altered by the following procedures laid down in the Companies Act 2013. So let's begin with the name clause. So if the company wishes to change its name, it can pass a special resolution with the prior approval of the central government. And if the company is registered with a name that is undesirable, then the company can change it by passing an ordinary resolution with the approval of the central government. Now coming to the second clause, the object clause. So as we have discussed earlier, the object clause defines the objectives and the powers of the company. So if they wish to change or alter the objectives or include new objectives into the company, a special resolution is required to be passed, and the changes must be confirmed by the authority. The document confirms the changes by the authority with a printed copy of the altered memorandum should be filed with the registrar. And if the company is a public company, then the alteration should be published in the newspaper, and also where the registered office of the company is located. And also the changes made to the object clause must be mentioned in the company's website. Coming to the next one, that is the liability clause. So as we have discussed earlier, the liability clause mentions the liability of each members and the shareholders of the company, and this clause cannot be altered except with the consent that should be written from all the members of the company. By altering the liability clause, the liability of the directors of the company can be made unlimited, and the liabilities of the shareholders cannot be made unlimited. The changes in the liability clause also should pass a special resolution, and a copy of this resolution should be sent to the registrar of the companies. So now coming to capital clause. So capital clause can be altered by an ordinary resolution. So it can be altered to increase or decrease the authorized share capital. Now coming to the next clause, that is the registered office clause. So the application for changing this clause shall be filed with the central government with some kind of a prescribed fees. Now if the company is changing the registered office, then the approval of the central government is required, and the central government is required to dispose of the matter within 60 days and ensure that the change of place has the consent of all the stakeholders of the company. Now let's look into the landmark cases related to Memorandum of Association. So the first one is Ashbury Railway Carriage and Iron Co. Limited versus Rich. So the rule of ultra vires was first laid down by the House of Lords in this case. So in Ashbury Railway Carriage and Iron Co. Company was incorporated, and in its memorandum the objects of the company were to make and sell or lend on hires railway carriage and wagons, to carry on business of the mechanical engineers and general contractors, and to purchase, lease, work and sell mines, minerals, land and buildings. So the company entered into an agreement for financing the construction of a railway line in Belgium with Rich, and all the members ratified the agreement. Later on, the company repudiated the contract and subsequently stocked the funds on the ground that it was ultra vires and the company, and consequently Rich instituted a suit for damages for the breach of contract against the company. Now, the contentions raised by Rich was that the contract was well within the meaning of the words general contractors, and therefore within the power of the company, and the contracts were ratified by majority of the shareholders. Now, in this case, the House of Lords held that the contract was beyond the object stated in the Memorandum of Association. The term general contractors indicates those contracts which are connected with the business of mechanical engineers. Even if all the shareholders or members agree or desire to make the contract valid, it would amount to go beyond the objects of memorandum. So, hence, the court held it to be ultra vires. The next case is Royal British Bank versus Turquoise. So this is also known as Turquoise's case. So it is a landmark company law case from 1856 that established indoor management rule. So in this case, the Royal British Bank lent money to a company, and which that company later became insolvent. So the bank alleged that the directors of the company had exceeded its authority in borrowing the money because the company's article of association required borrowing to be authorized by a company's resolution. However, the court ruled in favor of Turquoise, the liquidator of the company, and established the concept of indoor management rule. This rule states that a person dealing with a company is not required to inquire into the company's internal affairs or verify compliance with the internal procedures. If the person acts in good faith and within apparent scope of the company's authority, they can assume that all necessary internal procedures have been followed. The decision in this case had a significant impact on company law, providing protection to third party entering into transactions with companies. It acknowledges the impracticality of the third parties investigating a company's internal workings before engaging in a transaction, and allows them to rely on external authority of the company's directors. However, the rule does not protect directors who act fraudulently or dishonestly. This case uh, meditates the harness of constructive notice and ensure fairness in dealings with companies, while recognizing the need for practicality and efficiency in business transactions. Now coming to the concluding part of the presentation. So this is just a recap of the things that we just went through. So Memorandum of Association is a vital, essential, necessary document that is needed for a company in India. So this lays down the company's objectives, powers, limitations, and also serves as a guide for its operations. It is a public document that can be inspected by any person, and alteration or changes or amendment made to the Memorandum of Association should be in compliance with the Companies Act 2013. It cannot be used to engage in activities that are prohibited by law. Thus, we have come to the end of the presentation. Thank you.